Behold Darrell Brooks, the man who drove through the Christmas parade in Waukesha, Wisconsin, and creamed about 70 people. His murder trial was absurd beyond imagination. At one point, he oddly attempted to call the state of Wisconsin as a witness. In so doing, he was relying on a time-honored tradition among sovereign citizens, which we shall now ridicule. Hello out there. I am trying to get through.
With cold, blunt analysis, cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
Okay, so Darrell Brooks wanted the state of Wisconsin to take the stand for questioning.
Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here state of Wisconsin plaintiff. That's an entity. You have to name a person, sir.
The legal basis why that would not be accepted, Your Honor.
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
It's a bold strategy, Cotton. Let's see if it pays off for him.
Since the state is not a person and therefore cannot testify, the prosecution naturally objected.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word state of Wisconsin plaintiff for the witness name. The state of Wisconsin is an entity. It's not a person. The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Here is Darrell's rather twisted sovereign citizen logic.
Every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the state of Wisconsin.
Naturally, Judge Jennifer Darrow, who is no slouch when it comes to her knowledge of the law, although I quibble with her handling of Brooks, minced his logic into little bite-sized chunks.
Based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not? Or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
So where did Darrell get his strategy? The internet, of course. Sovereign citizens are relying on an informal phrasing of the Sixth Amendment that they paraphrase as the right to face one's accuser. They think that because the state is the accuser, then that means they can call the state to the stand. And since the state is not a person and can therefore not take the stand, then all charges should be dropped. Well, yeah. Of course, the state could never convict anyone of any crime with this interpretation. So if someone, say, assaulted the sovereign citizen, then the law would have no recourse other than to shrug. My gut feeling is that the sovereign citizen strategy would be conveniently dropped if such a thing happened. No one has ever accused sovereign citizens of being consistent. There is another major flaw in the sovereign citizen strategy. Now, suppose you're a sovereign citizen and you really think this is a great idea. Okay, suppose the judge went along with this scheme. The problem is that when it came time for your turn to present your case, there's no one in the courtroom to take the stand when you call your witness. And since the state would be your witness and not the prosecutor's, then you will have gained nothing. You can't claim a default judgment because it was your witness that failed to show up. Well, enough of that. What does the Sixth Amendment actually say? In all criminal prosecutions, the accused shall enjoy the right, among other things, to be confronted with the witnesses against him. Now, this sounds rather weak. So what does it really mean? Well, rulings made by appeals courts have established that this amendment also extends to the right to question any witnesses the state may produce to try and convict the accused. Essentially, the Sixth Amendment establishes the right to cross-examination. Just to show you how far this amendment goes to protect the rights of those accused of crimes, let's go to the trial of Ronnie O'Neill. He was accused and convicted of murdering his wife and daughter, and most importantly for this video, stabbing his own son. Ronnie represented himself. And one of those witnesses the state put on the stand was, in fact, his own son. So Ronnie got to question his own son about the event surrounding him stabbing him. Why? The Sixth Amendment.
Did I hurt you that night of this incident?
Yes.
I did. And how did I hurt you?
You stabbed me.
A lot of people howled at the inanity of allowing a man to question a son he stabbed. But if the son makes claims against his father has the right to call those claims into question by, well, questioning him. By the way, some countries would have avoided this problem by requiring that someone else question the boy. Now, why would the Founding Fathers want such an amendment? After all, if you get accused by someone of a crime, you would naturally have a right to question the accuser, right? Is this right so obvious that it need not even be codified? I mean, what kind of power-hungry tyrant of a government would quash such a fundamental right, one that makes complete sense to any reasonable living being? Sure, maybe in some faraway third world countries ruled by despots, but in America? Well, there is such an entity in America that does not provide such a right. The university. That's right. The vigorous defenders of human rights, the bastions of freedom, the holders of all things intellectual, the drivers of political thought. They don't provide this right once a student is accused of a crime.
Saif Khan was a senior at Yale in 2015 when he was accused of assaulting a fellow student on Halloween night. The woman claimed that Khan raped her after she admittedly had too much to drink. Khan denied the accusations, was arrested, and faced a criminal trial. It took a jury 3 hours, just 3 hours, to acquit him on all charges. The story, of course, didn't end there. There was a hearing on Yale's campus in which Khan and his lawyer were unable to cross-examine his accuser. They were not even allowed to be in the same room when she testified. Yale suspended Khan and eventually expelled him. But now the Connecticut Supreme Court has found that Yale's kangaroo court was so unfair, they issued a ruling in Khan's favor, in the accused favor. They wrote that Khan's lawyer's inability to cross-examine the accused reduced them, and we're quoting now, to the role of a potted plant, saying fundamental fairness requires meaningful cross-examination in proceedings like the one at issue. They found Khan could actually sue his accuser for defamation.
The university's rationale is that by not allowing the accused to question the accuser, it encourages students to come forth with their allegations of sexual assaults perpetrated by other students. And of course, the downside of allowing allegations to go unchallenged are obvious. Well, they're obvious to us. Somehow, these entities run by people with PhDs can't quite figure it out. And by the way, the university does not hold to the tenet that it is better to let a guilty man go free than to convict an innocent man. If you want to hear more about that case, subscribe to my channel and stay tuned for a future video. In short, this sovereign citizen ploy to throw out a case has zero chance of winning because it rests on a layman's phrasing of the Constitution. You have the right to question anyone that takes the stand and accuses you of a crime. You don't have the right to question the state as a witness. You just don't. Be sure to like my video and again, subscribe to my channel.